Good afternoon, ladies and gentlemen. Let us begin our work. Despite rather hot weather, I believe that we can expect very hot debates and rather vivid discussions, because we are discussing the topic which will draw the conclusions of the work which we have done along with the members of the WTO within the 18 years of the accession process. And we have to discuss how we should take advantage of the accession to WTO in order to strengthen the economic reforms and to complete the legal reforms in Russia. This topic is being discussed in Russia because the paperwork related to the accession would be discussed and studied by the State Duma within the next 3 months. There are different standpoints concerning the accession. Certainly, a lot of criticism has been raised, and there are many positive moments too. And I'm glad that today we brought together really well-known experts in the area of trade law. Let me introduce them. Dmitry Lekashev, head of the reference service of our permanent representative office in Geneva. He dealt with the reform of the Russian legal framework in Russia for many years. To his left is Mr. Scott Anderson. He's partner of Sydney Austin LLP from Geneva. He, for many years, worked as a legal advisor in the permanent representative office and represented his country in more than 30 litigations which were examined by the commercial courts. He also participated in many discussions held by the WTO members, and he's one of the outstanding lawyers who were nominated by a number of rating agencies. For instance, he was nominated for the Lawyer of the Year. Next to me is Mr. Crosby. He is different from all of us because he graduated from the St. Petersburg State University. He also works in one of the Geneva companies called King and Spalding. He deals with trade law, trade litigations and disputes. He's one of the leading experts in terms of international trade, and this was appreciated by Chandra's Europe and other legal journals and a number of other editions. And last but not least, Mr. Telikovsky, partner of Gordner Ladner and Grevey from Canada. Greg consulted the government in more than 30 different procedures how to settle down the litigations raised within WTO, and he represented his country in the Doha round of negotiations. Greg is the best lawyer of Canada in the area of trade law in the year 2011. So the panel discussion seems to be very representative, very interesting. Let me also introduce Catherine Mayorova. She's my deputy in the Ministry for Economic Development, Department for Trade Negotiations. She started as a negotiator concerning the services, and in the last years she dealt with systemic issues and participated in the development in the Russian legal framework and contributed to the Russian accession to WTO. I believe that our discussion should consist of two blocks. First, we should start with discussion of the changes which should occur to the Russian legislation as a result of the accession to WTO and how we may take advantage of the procedures of dispute settlement. After that, we're going to discuss those issues within the discussion, and we'll answer the questions raised by the participants. Later on, we'll discuss the application of the issues of the trade remedies, the trade regulation, and after that we'll engage a discussion. I am passing the floor to Dmitry Lekishev. Dmitry, you participated in the development of the Russian legal framework, legislation. So how would you estimate our position in terms of bringing the Russian laws in compliance with the WTO framework? Thank you so much, Mr. Chairman. Good afternoon, dear colleagues. In my presentation, I would like to touch upon three issues. First of all, make an overview of the work we have done in terms of bringing the Russian legislation in compliance with the WTO requirements. Secondly, the situation around this issue as of today, what we have done in that area and what we have to do, and the legal repercussions and consequences and applications for the Russian and foreign entrepreneurs and stakeholders, as well as for the lawyers after the WTO requirements and laws are incorporated in the Russian legal framework. A few words about the essence of the work we have done in terms of the adapting of the Russian legislation to WTO requirements. It is based on the legal grounds of WTO, namely on the item which says that every country commits itself to bring its laws in compliance with the WTO requirements. And during the discussions on the accession to WTO, as a new member, as a would-be member, any country studies and examines the laws of WTO in the light of how to bring in compliance their own legislation, and also they study and examine the gaps and differences in the legislations. In the Russian context, this work has to be completed before the accession discussions and talks are over. But in case there are gaps between the national law and the WTO norms, then the country commits itself to settle down all the differences by the moment the country accedes to WTO. This is one of the privileges of any emerging market. But Russia proceeded from the fact that our legal system and framework will be brought in compliance with the WTO norms by the moment Russia becomes member of this organization. What's the demand and requirement of the WTO concerning the national legislation? First of all, this is compliance of the national laws with WTO rules. Secondly, this is a mandatory requirement that all the procedures in terms of the lawmaking and law adoption, those processes should be transparent, and the law enforcement practice means that the laws should not remain just on paper or a lip service, but should be enforced to the extent which is required by the commitment of the country as a member of the WTO. In Russia, The work on bringing the legislation in compliance with WTO rules started in the year 2000. In the year 2001, a decree was adopted by the Russian government on bringing the national legislation in compliance with WTO rules. And this plan adopted the list of the laws and bylaws which are to be adopted. This list included a number of basic federal laws which actually created the foundation for the state regulation of the foreign trade activity. I will not go into detail describing all those laws. I believe that many of you know them very well. Just let me illustrate my idea that the basic principle of GATT 94 and other agreements of the WTO found their places in the process of adopting and designing of the laws in Russia. And first of all, now this concerned the law, federal law on the state regulation of the foreign trade organization, such as the laws on transit, on the most favorable regime, then the territorial application of the foreign trade legislation, non-discriminatory application, etc. Also the remedies which were brought in compliance with the correspondent agreements of WTO. Then a law 183 actually made a foundation of the technical regulation, and actually we signed the WTO agreement on the technical barriers in the trade. I would like to highlight that within the year 2000 and later on, a number of laws was adopted, setting the norms in different areas, such as, for instance, copyright and intellectual property protection. But then these provisions were merged when the Civil Code of the Russian Federation was adopted in a new version. In all those laws, and this is what I would like to stress, the WTO provisions were taken into consideration, especially its requirement of the transparency of the drafting of the laws and enforcement in the trade area. And this is what is specified by GATT Article number 10. And our partners also paid great attention to the transparency in the customs administration, technical regulation, enforcement of sanitary and veterinary measures. And this most important principle of WTO, namely transparency of the legislation, is not just a rigid norm, because it's always being improved, and this process goes on. In particular, the multilateral trade negotiations on simplifying the trade procedures enjoy great chances of being agreed by all the members, and we believe that after Russia becomes a full-fledged member of WTO, this would become one of the spheres in which we may contribute to the improvement of this provision of this legislation, certainly proceeding on from the benefits for Russia and for other members. All in all, within the negotiation process, about 50 federal laws were adopted and different regulations by the government related to WTO regulation. And this is saying nothing about different recommendations and other paperwork and documents. And are the bylaws adopted within the customs union. All those laws and bylaws and effective laws, which actually 500 in number, were tested by the WTO and examined by the members of the WTO within all those years in terms how they comply with the rules and requirements. Not all the norms were perfect. The differences and deviations were detected. But again, along with the negotiation process, some amendments were introduced into the effective laws. And actually, this work was done until all the differences were eliminated. I would like to stress that the work on bringing the legislation in compliance with the WTO was not done in isolation, and it was not specifically designed to appease the WTO. The main essence of adopting new laws was the main aim was to provide necessary remedies and necessary protection for the market economy in Russia, to create adequate conditions for the business and entrepreneurship in Russia. And actually, the laws adopted in the WTO member states became a kind of a guideline for us to settle down certain issues here in Russia. And the incorporation of WTO founding principles such as non-discrimination, transparency, and other principles into the Russian legislation actually improved the conditions for the Russian business.
The work to bring the domestic legislation into the compliance with the WTO rules have been completed in 1998, and starting from that time, the changes made into the bylaws and laws were accompanied with the work on incorporation of new norms of the Russian legislation into the legal framework of the customs union, which got a bigger part of functions and rules to in terms of foreign trade. Ekaterina Mayora will tell you just in a great detail about this, but I would like to show that by that time the bigger part of the Russian national legislation were brought into the compliance with the WTO rules, and the number of basic legislations of our partners in Belarus and Kazakhstan in customs unions were drafted on the basis of new Russian laws. All this led to the situation that the task to establish the legal framework for the customs unions was to some extent facilitated, and the union was facilitated at the same time because they saw that these were the norms which existed in the Russian legislation, which would allow to conclude the negotiation processes regarding the accession to the WTO. In order to assess the status quo as of today, I would like to come back to the number of requirements of the WTO to bring the legislation into the compliance with the WTO rules, the transparency, dispute resolution. I must say that as of today, 99% of the Russian legislation has been already brought into the compliance with the WTO rules. Of course, I can cite some examples regarding the pieces of legislation which is expected from us by the date of the accession, but I must say that these norms established rather specific private norms, legal norms, which require either changes or adjustments which wasn't taken into account in the domestic legislation, like the economic operations which require the GATT rules to be incorporated regarding the governmental or government-controlled entities in the foreign trade transactions. A number of amendments to the Russian legislation stem from the requirements for the Russian Federation in the service sphere. We have to solve another systematic issue, which is the creation of the system for the provision of notifications and provision to the WTO the updated information regarding the trade remedies to be adopted by the Russian Federation, which would require the adoption of specific bylaws. But the main task, as it seemed, is to streamline the effective implementation of this legal framework legislation and to avoid the adoption of new legal norms which would be in contrast to the WTO rules, and to ensure transparency in decision-making and legislative process. In conclusion, I would like to dwell on possibilities for Russia after the accession to the WTO for the trade entities, be it domestic or foreign ones, and for the lawyers protecting their interests. These opportunities can be mentioned in the following manner. I wouldn't like to go into the presentation of Mr. Crosby, but just would like to mention the access to the dispute resolution mechanism in order to assess and resolve the dispute between the economic operators who can apply to the competitive bodies in order to initiate the dispute resolution mechanism between trade entities. Then the possibilities of the redress of those measures that are adopted in the trade, in the courts, and in compliance with the Russian legislation, which was brought into the compliance of the WTO requirements. And the third element, this is the possibilities to redress the national measures which were established in according to the Russian legislation, with a direct reference to the provisions of the WTO agreement as an international treaty, because the conclusion of the international treaty of the accession of Russia to the WTO makes it legitimate the relations between the trade economic operators, Russian and foreign ones, and to solve all the issues on the basis of these legal norms. And these legal norms become prevailing in terms of their relation to the domestic legislation and the Russian Constitution and other legal measures. Just briefly, I would like to mention the WTO norm, the appeal of the administrative measures. This is the third point of the GATT 94, which determines that the members of the WTO should either create or establish or maintain the respective administrative or legal procedures to redress the administrative actions which contradict the WTO rules. You know very well that we have set up this system in Russia, and to a big extent it covers a huge range of issues, since the Article 10 was intended for the import of goods, while other procedures to redress these issues can apply to all decisions to be made by the government. So, in other words, after the accession of Russia to the WTO, we will have new possibilities to protect legally the interest of the economic operators. But much would depend on you, dear colleagues. I mean, those present in this room. Thank you very much. Dmitry, thank you very much. Now let's talk about sales. Yesterday, literally, the real fact, the representative of the Canadian government turned to us and they asked the customs union prohibited the import of seals into the territory of the Russian Federation. And we as the Canadian representative believe that this prohibition is not in compliance with the WTO rules, and Russian Federation has no longer the right to make these decisions because it's now the prerogative of the customs union. Ekaterina, can you give us an advice what should be the reply to the Canadian representatives to this extent? Thank you very much. Yes, indeed, it's not an easy question. I believe for the government of Canada and for the Russian government as well, and maybe for other government or supranational body, which is now governing the bigger part of the trade activities, Eurasian Trade Commission, which has been in existence so far. But just coming back to the history or background of this negotiation process, Mr. Medvedkov has said, and you know very well, that starting from the January 1st, 2010, the customs unions got in full operation between Kazakhstan, Belarus, and the Russian Federation, and we delegated the bigger part of our functions to this union on a whole range of issues. You see them on the slide. The application of import duties, non-tariff measures, phytosanitary measures, safeguard measures to protect domestic market, and now we find ourselves in a quite a unique situation at the point of accession to the WTO, because in fact, according to the WTO rules and Marrakesh Accords, so only a state or a custom territory can join this union, which has the full autonomy in decision making. At that moment, Russia has no longer this kind of autonomy, legal autonomy. And of course, in the negotiation process at the last stage, we were confronted with quite a complex task to explain to our partners in negotiations and to understand better how can we implement these specific rules of the WTO, since the customs union, as it turns out, is not related to the obligations under the WTO, and Russia, after joining the WTO, should implement both WTO rules and those obligations under the customs union agreement. And we should remember that our partners, Kazakhstan and Belarus, are so far not the WTO members, and accordingly we are not in a position to think seriously about to claim that we have customs unions as a member of the WTO, which would solve all our problems. But I think this is the matter for the future work. I wouldn't like to give any assessments how far from we are from this. Maybe first Kazakhstan and Belarus should join the WTO, and after that we should launch the negotiations to get the status of for the customs union in the WTO. So at first glance it was quite a risky endeavor for us, because our 18-year negotiation experience has shown the longer we are dragging in the negotiations, the tougher the rules for the exceeding state are, and we made two observations. First of all, the higher parameters of the economic development of the exceeding country, so the tougher the rules presented by the negotiation counterparts. This was faced by us in 2010, and those requirements were different as compared with the ones with which Russia could have been faced after the disintegration of the USSR. And the second observation was quite evident that after each new accession, so each new accession raised the level of the accession requirements even higher, since countries are trying to avoid the obligations of WTO plus to develop further the requirements of the WTO. But looking at the experience of our partners, Ukraine, China, and others, their negotiation package contain these kind of requirements which complicate the life of negotiation teams and those countries which still are in the process of negotiation. That is why we faced the task to complete the negotiation process and to find a proper solution in terms of guarantees and safeguards that Russia would be able to implement the obligations under the WTO agreement despite its membership in the customs union. And the solution to this problem was the signature on the accord to implement the customs union within these trade economic territories, which was signed by all members of this customs union. It became a part of the legal customs framework and a part of the legal framework of Russia. And this agreement or accord contains a number of important obligations, sometimes unprecedented ones, which objectively explain the unique nature of the situation in which we found ourselves. And the most unusual thing in this agreement is that it establishes the hierarchy of the international treaties abided by Russia, and it establishes that the requirements of a country joining the WTO has the prevalence over the decisions of the customs union and those decisions which are to be made by the European Economic Commission. This agreement directly provides for the fact that those decisions that are not in compliance with the WTO should be brought into the compliance to these rules. And this treaty also provides for the following provision that rules in the country joining the WTO cannot be changed or amended because of the specific agreement to be concluded in the framework of the customs union or a court decision or whatever. So these general rules have some exemptions, and of course they apply to those areas which still the members of the customs union trying to govern independently. The customs duties competence is not conferred to the supranational level. The domestic of rules, trade rules, and IPRs, so all these issues, Russia, Kazakhstan, and Belarus continue to govern independently from each other, and therefore, should we look at the situation in a simplistic manner, the decision on services would not to be made by Russia would not be obligatory for mandatory for Kazakhstan. Kazakhstan can apply its own rules. The same is true for possible deviations from general WTO general rules. If a country joining the WTO can agree some provisional transitional period or some exemptions, then these provisional exemptions or specific measures would continue to apply. The Russian Federation agreed the temporary period for applying the measures which are not in compliance with the WTO rules on the car assembly provisions, and during this period we can maintain these rules. The same exemptions are negotiated by Kazakhstan, and the agreement on operation of the customs union agreement would not prevent our Kazakhstani and Belarus colleague to make this kind of provisions. What would be the changes in the customs unions? I'm just referring to the provision of the treaty which require to bring all our domestic rules into the compliance with the WTO rules. Changes, we don't believe there would be many changes. They can be split in 4 groups. Procedures for decision making. Dmitry has just focused on this topic, on requirements for transparency in drafting and making decisions by national authorities and by the authorities of the customs union. Maybe I would dwell specifically on the essence of these changes and what is the difference of these changes as compared with the WTO rules on changes. They contain many similar documents, GATT and others, and the main idea is that the economic operators could have a possibility to, or could be granted access to the published measures which apply to the foreign trade activities they're engaged in, and that these measures would not be applied in a retrospective manner. First, operators should be aware of these measures, and after that they should apply. This is the basic requirement of the WTO, and we went even further, like any other joining countries. And as an addition to this basic requirement, we have agreed that these rules to the trade should be made public and should be made public to all concerned, even at the drafting stage. And we have agreed that we would publish the drafts of these normative acts or bylaws just maybe 30 days in advance, but there is no strict requirement in terms of the dates. But this requirement to publish and to show the drafts to the economic operators of would apply to the decisions of our supranational body and the decisions of the Eurasian Economic Commissions, which is dealing with the economic issues. The second block is referring to changes of the law enforcement practice, and as an example, I must refer to the customs area, where our legislation, be it domestic, and those provisions which are applicable in the framework of the customs union, which established either by customs code of the customs union or other decisions by the Eurasian Economic Commission, they are generally brought into the basic rules of the WTO. But what is more important here is how would they be implemented in terms of our economic activities of our trade operators. For example, the custom value determination and the burden of proof of this value should be borne by the customs officials, but not those declaring this value. Sometimes we fail to properly apply this rule, but after we join the WTO, we should pay more attention to this and to ensure the proper implementation of this rule by our customs authorities. The third block would deal with the changes in the specific rules in the customs union, and I must say, maybe mention the veterinary requirements, which are now being scrutinized in terms of their compliance with the international rules, since the WTO rules require from its members that all these measures would be in compliance with the international standards, and to prevent any deviation or to ensure the scientific explanation of this deviation. So our task is just using this time till the accession to scrutinize all the veterinary and phytosanitary measures in terms of their compliance with the international standards. And once we see that they are not in compliance, we need to find a proper explanations for that. And the last block of amendments which we need to implement, amendments to the agreement of the customs union. It's not an urgent task. In our opinion, we can wait and see, and not to link it to the date of the accession. I explain why. Here we are talking about some general requirements in the agreement of the customs union, which provides for the legal framework for the members of the customs union, which should decide on either adoption or not adoption of the non-tariff measures. So there are reasons for adoption of these non-tariff measures, which sometimes lack correspondence with those explanations or reasons which are allowed by the WTO rules. So this norm would not be applicable. It would be applied through the decisions of the Eurasian Economic Commission, and we are convinced here that we would be able to avoid the conflict with the rules of the WTO on the basis of this agreement of the functioning of the customs union, because the Eurasian Economic Commission should be guided in its operation not only by the agreements of the customs union, but also by the rules of the WTO and those obligations assumed by Russia. And should it not be the case, and we proceed into the responsibility or liability things, if it's not the case and the customs authorities would violate our obligations, then the responsibility would be in Geneva, would be borne by the Russian Federation, because neither Kazakhstan or Belarus are the members of the WTO. In order to avoid this situation, In fact, we think about this in the framework of those procedures which is now existing in the supranational customs union agreement. So I believe that would allow us avoid this problem. You know, Eurasian Economic Commission since recently consists of two chambers: Collegium, which is the operational authority and is independent from three governments, and there is the Council of the Eurasian Economic Council, which consists of the representatives of the governments of these three member states, and it can renounce or suspend the decisions to be made by the governments of these three member states. So in this chamber, we at least have a possibility to block the decisions which are in conflict with the WTO rules. Sometimes it's not enough. We can block these decisions, but we won't be able to ensure the adoption of a decision which is required for some purposes, just for example, to ensure the reduction of customs duties, which is agreed upon in the WTO negotiation processes. If it is the case, then we would have a possibility to appeal to the court of the Eurasian Economic Commission, which is not in compliance with the WTO rules. But here we probably should note,
despite that this is a kind of hypothetical situation, as far as until now we managed to cooperate well with our partners, and no decisions which would contradict WTO rules were adopted. But if hypothetically such situation occurs, we have to look at the regulation and at the deadlines and duration of the examination of the cases, and not violate such deadlines which are allocated by WTO for the resolution of the trade disputes. There are very strict guidelines as to how the guidelines should be, how the consultations should be held, and the mediation procedures and the arbitration procedures. We believe that if within the customs union we have any problems which would contradict WTO, then it should be resolved with bringing the resolution in compliance with the WTO. And I would like to note also that, and it is quite an important moment, and Dmitry in his speech also has highlighted it, saying that there is an opportunity to appeal, to challenge the decisions taken by the national courts. And I would like to take note of the fact that in compliance with this certain agreement, the economic operators and legal and physical persons may challenge the decisions taken by the national courts. So although there is always an option of the national courts, and this is a kind of arbitrary question, because then a question may arise is how the national courts would interpret the WTO provisions and agreements, taking into consideration that the WTO legal framework is very flexible, it evolves always, and It also consists of numerous decisions taken by the WTO member states, starting from GATT adoption. And this is also about the dispute resolution. So it means that there are some practical applications of such opportunities, but they may sound not very optimistic in practice. Let me draw up some conclusions for my presentation. So my first conclusion is that we have established a kind of a unique hierarchy of international agreements, according to which WTO provisions would prevail over the customs union provisions and agreements. And one of the repercussions of this unique situation is that we, in fact, will harmonize the norms and standards developed and adopted by the customs union with the rules of multilateral trade. This scheme, in my opinion, is of a temporary nature, because at a certain moment of time it should cease its existence, and the customs union will accede to the WTO and will be bound by certain commitments, and will have certain rights as a WTO member. And the last conclusion is that this scheme of automatic harmonization finally will be advantageous for business, because it would allow, even for Kazakhstan and Belarus, which are at different stages of accession to WTO, will allow these countries to comply with the WTO regulations and rules. Thank you so much for your attention. Thank you, Catherine. It was quite a nice overview after Dmitri's and Catherine's presentations. You may get an impression that there are no problems, that no contradictions exist, but at the same time, what we hear from many experts is that Russia probably will never be able to stick to its word, will never be able to comply with the regulations, and that there would be much more disputes raised by the Russia's accession to WTO. And at the same time, many companies which are tired of discrimination of their products in the international markets, they are looking forward to Russia's accession to WTO in order to start fighting those barriers. Daniel, how the situation is going to develop, and how the procedure of dispute settlement might be used by business and by the governments to protect their interests. Thank you, Maxim, very much. And I would like to thank the organizers of this event. I am very glad to be back to the city founded by Peter I. I was a student there more than 2 decades ago. I studied in Leningrad State University, as it was called then. As far as Russia is not a member state of WTO, I actually had no opportunity to speak Russian, and therefore let me switch to English. And next time we meet, when we meet again in the framework of WTO, I will speak Russian. I promise.
So the theme of the next discussion, as was just introduced, is how are the WTO rules used? How will they be used against the Russian Federation? Will you be able to live up to the obligations that you've undertaken and how your businesses benefit by using these rules and the laws that are supposed to conform to those rules to break down barriers in foreign markets. And then I'll give you my prognosis for dispute settlement in answer to this question of how I see and to give you a view of what people are talking about in Geneva about how Russia will act as a member and how you will use the system. So, starting from the dispute settlement understanding, which is part of the WTO agreements, WTO dispute settlement is related to, first of all, trying to settle disputes without litigation. That's the first bedrock of the system, that the rules are supposed to be strong enough and clear enough that you won't have to resort to litigation because you can convince governments to comply before a case is brought. So we'd like to reach mutually acceptable solutions to problems through negotiations. Now, of course, if litigation is necessary, the goal is to remove that offending measure, so that will be good for business. And right here, I'd just like to point out that, of course, the dispute settlement system and all of the WTO activity and negotiations are government-only. Businesses don't have a place in the room unless they're invited to be on a delegation in a particular situation that a government invites them. It's become common for lawyers to be present and represent governments in dispute settlement, but the private sector itself does not have a direct role there. So, since the WTO purports to be what members call a rules-based system, I've tried to outline what any system of law, and I guess thinking about the broader scope of this conference, thinking about law in general and public international law, what do we need to have a system of law that encourages the settlement of disputes? And I wanted to flag the set of principles for discussion later in application to Russia specifically, but pointed out three issues. One, clear rules. Two, a process to enforce those rules. And three, when those rules don't benefit all members or the business moves on and we have different issues, we need to have a mechanism to develop new rules to respond to the changed situation. So in addition to those basic pillars of international law, of our system, in order to encourage that rules-based system to work, in my view, we need to have three kinds of encouragement to use that system. And the first is based on fairness, of a moral and political approach to the system where all countries benefit from those rules. And secondly, we need to have a long-term interest in that system, not just complying with a specific case that might be against you, but developing a legal system of expectations and precedent that will serve your interests in the long term. And then third, and very important for the Russian Federation, and one thing that's still a question mark in my mind, I think a lot of people's minds, is, and I just heard a lot during our lunch break downstairs when I said I was speaking on this panel, and a few Russian people said, well, why do we join the WTO anyway? We have no economic interest. And I tried to defend that the best I can and talk about it, but it's an issue that that will need to be clarified as you go along in your membership. So now to transition to more of a little bit of a technical explanation, we turn to the substance of some statistics. That we have 436 disputes that have been filed since January 1995. And this is way more disputes have been brought and settled since 1995 than the entire period of almost 50 years from 1947 until 1995 under the GATT, the WTO's predecessor. But among those 436, what I'd like to note here, and not get into a technical discussion of how the rules work, because a lot of us are lawyers in the room, and reading a set of rules and applying them and litigating is the easy part, I think. The hard part is, how do you, as a government official, as a lawyer trying to help a business, how do you solve that problem without litigating? And that requires a knowledge of the rules and a knowledge of the people and how the system works, so you can convince people that you have the winning case and they shouldn't take this to a dispute because they're going to lose. It's going to be a bad public loss for them. So here, 246 disputes, of those 436, more than half are not in litigation. And the reason I mentioned this first reference there, the WT/DS1, that's the system of marking documents when disputes happen. That DS1 was very interesting. I don't think anyone expected that the first WTO dispute would be between Singapore and Malaysia regarding polypropylene exports. But it was a long simmering problem between those two countries where there were trade restrictions that couldn't be resolved and couldn't be resolved. And as soon as the WTO was founded, this case was brought and settled. There was no litigation in the very first dispute, as in most cases following that, no litigation. Some are in consultation, which can go on forever and ever and ever without settling a dispute. Only 86 have been formally terminated. And then 18 panels have been established, but never composed. The parties never went ahead with the case, or they're in the process now of deciding who the panels are going to be. My proposition to you is that even this, 246 that are not in litigation, are really just the tip of the iceberg. In my practice, what I do is 90%, 95% solving problems using WTO rules without ever litigating. And I think that's the strength and bedrock of the system, is when you have clear rules and a mechanism for enforcing those rules and a good negotiating system, then you can avoid the disputes. So here, for every dispute that you see, 400 disputes at the WTO, there, I would say 10 times as many are resolved without ever seeing any light of day, and just through diplomats or even businesses directly contacting counterparts in other countries in the regulatory system, whereas it was just explained that Russia now has a transparency mechanism where before making regulations, now you publish them. Many countries have that, and it's very helpful because businesses can come in and make arguments. Well, we agree with the end that you'd like to achieve, but the way you're doing it, we think violates WTO rules. So if you want to avoid that problem, change your rules, and we have some suggestions for you. And that kind of open communication and filing system with the public really helps that process along. Now, the reason I mentioned this iceberg concept is because it's not public, it's not official. Your government might not even know that your businesses are going and talking with a foreign country. A lot of times that happens because businesses are afraid that it will turn into a bilateral dispute, and they'd rather try and do it quietly. Of course, some governments would rather have their businesses communicating with them, so your government will need to work out a way that businesses can trust that they can work with each other to find the right way to solve these disputes. One of the interesting parts about the stability of the system and the strength of dispute settlement without litigation is, in the beginning, in 1995, 1996, and through the 90s, as a lawyer, you would go and speak with the government, and they would explain, well, we don't know what that means. There's no precedent on that. And now, after 15 years of practice, we can point to a lot of issues that have been resolved. There is a lot of precedent. There's a lot of case law. So even if a specific issue hasn't been resolved, we have now a system of interpreting that law. Whereas lawyers, we can look at that treaty and try to foresee the results and argue those results to governments. So I wanted to offer some practical observations as a practitioner and an observer of how governments and some businesses resolve disputes informally using WTO rules. First, as I mentioned before, one of the most direct ways of resolving disputes is having a direct discussion with the government involved. And sometimes businesses are afraid. The most famous example is China, where most businesses exporting there, a lot of them are also manufacturing there, and they don't want the Chinese government to be angry with them, and so they avoid bringing disputes or even mentioning problems. Of course, when everyone steps back, even the Chinese realize that that's not the greatest way to encourage an economic system to develop. So even the Chinese are looking for ways to have people come very quietly and express problems to them without making a big public issue out of it, because then it's hard for governments to back down. But finding ways to communicate directly with governments, both to the Russian government and by the Russian government and its companies and counsel to foreign governments is a very important aspect of avoiding disputes and litigation. The second part is very difficult for business, and even for government representatives when you're under political pressure, because the WTO and its rules don't go anywhere fast. It's not a hurry, and even though it might be a big deal for your government or your company, unless you get up to a very high level, the response might be very, very slow, and all the time slower than businesses want it, because businesses want it to happen yesterday. And sometimes when you're under political pressure as a government representative, we get calls from government deputy ministers and even ministers saying, "I need this to move right now." And we say, well, that's not really possible. And they say, who do I need to call? Who does my president need to call? It's got to move right now. So it's very interesting calls sometimes. And the last point here on observations is a point about resources. I started by saying no surprises, no hurry, no resources. The biggest problem that I see in solving disputes without litigation is the lack of resources put into WTO issues at an early stage. And Scott will talk to you later about anti-dumping and trade remedy rules. But as lawyers, you'll see that when you participate in a trade remedy process, you hire lawyers, private sector hires lawyers. It's not a government responsibility. And if the private company doesn't hire lawyers or doesn't give them a big enough budget to really do a good job in the case, they will not lay the factual background that's necessary for the government then later to bring the case at the WTO. And that is the biggest issue in all of the litigation that I've seen, that you're at the WTO and you say, God, I really wish they had made this basic argument in the underlying investigation so I can use that now to my government's benefit at the WTO stage. But investment in knowing about and applying WTO rules is just like any other investment, an allocation of funds that a government makes, that a private company makes. You have to see a return on your investment. So initially, there will be a lot of interest, and a lot of lawyers and businesses will try to figure out how to use the system for their own good. But according to the second principle, they can't be in a hurry, and you can't expect a return tomorrow. But the government, I think everyone recognizes that the Russian government has a pretty good team, and there's been a very good development of expertise at the government level. And the next thing that needs to happen is beyond the trade remedy work and all the dumping and subsidies, steel and whatever companies that have been subject to these cases, they all know basically what those specific rules are. But how does your economy as a whole and all of your companies benefit from these rules? It takes an investment of someone's time at university level, teaching, think tanks, and a combination of not only knowing the rules, but being a good enough business person to translate the academic knowledge into the business sense of actually solving the problem. And I think the last mention here, private sector, not only in anti-dumping disputes where you're directly the participant, but in every single case, in every country. I'm not aware of a single dispute that's ever went anywhere just because a government thought it should bring a case. If you're a lawyer and you see a problem, or you're a business and you're thinking about, you're being blocked from a certain kind of business, it requires that business to invest time and money to support the government. Because the government, and no government anywhere, is going to be able to figure out every problem for the private sector. I think that's my biggest message for counsel trying to practice in this area. If you need to convince people to pay you, because that's what lawyers are there for, not just to work pro bono all the time, although it's nice. But you have to be able to translate these opportunities into business opportunities for yourselves and for businesses, and therefore help the government in its economic plan. So it all works together. So now talking about the application of those principles in practice to the specific situation in Russia. I'll answer those three questions, the principles, speak to them, that I posed in the beginning, and ask, do clear rules apply to Russian interests? Two points there. Russia did a very good job negotiating its working party report, its contract, this guy, these people sitting on my left. And the reason you know that is because you read through it and you say, my gosh, what does that mean? And that's the goal of negotiators. When they can't solve a problem, they do what we call punt. You kick, and you hope the other side doesn't complain too much, and you've been at it and you're fighting, and in the end everybody gives up, and you put some language down that they think means one thing and you think means another, but a third person has no idea. And that is the result of many of the very difficult pieces of the negotiations. I see Maxime smiling. Congratulations again. But what that means is there may, if that interest goes against someone else and they don't agree with what you think the language means, that leads to a potential for a dispute. That's more anecdotal. A more practical thing is, I think most people observe that the most practical interest facing Russia today is in trade restrictions in the form of unfair trade remedy, anti-dumping subsidy proceedings, where foreign governments apply measures against Russian products that are more competitive on price, because a lot to do with your natural resources, but a lot to do with also technology and investments that have been made, that you can sell products better and export them for a cheaper price, and countries just block your products based on some made-up rule. And a lot of times, those rules seem to me to violate the WTO standards under the anti-dumping agreement. Scott will talk about that. But some of those major rules, which have become major, important protectionist tools for your trading partners, are unclear. The rules themselves are unclear. And we see in the Doha round of negotiations some attempts to clarify those rules, which leads me to the third point. Is a mechanism functioning to develop new rules to clarify those points that matter to you? The answer is no, because the Doha round's going nowhere. And the only way to clarify those rules is through the interpretation and dispute settlement. So that's one of the areas that we have an issue made up for. And I would add a kind of fourth point here about clear rules and shifting interests. One of the big issues in Russia's economy and WTO accession was the availability of cheap gas. And some people can't understand why gas is cheap in Russia, and I don't understand them, because you have a lot of something and there's something called supply and demand. The United States asked similar questions, why is your gas so cheap? Until we all of a sudden in the United States discover something called shale gas. And we start exporting gas because the national price is so low. And then people start questioning, why is the price of shale gas in the United States so low? And how can you export it so high? Why is there such a big difference? It must be subsidized. And then the United States starts getting on your side more, I think, in that debate. So positions change as we go along. So, kind of getting to the end here, is Russia encouraged to follow those rules according to the second set of 3 questions. Has Russia been treated fairly and objectively in its accession process, and therefore encouraged to, once it joins, to act in a fair and objective way? And I guess as an example, maybe a bad example, you look at Ukraine, who feels that it had a very difficult time joining the WTO, was treated unfairly, and is now blocking everybody else's accessions, except for yours. You know, they're blocking Yemen and Laos and all the poor countries out of spite, it seems, because they were treated badly. And people wonder, well, did we give Russia such a hard time that it's going to give us a hard time when it finally joins? Legal encouragement. So there, I would say, yes, Russia has a moral and political encouragement to act in a cultured, reasonable way, because it's Russia, and I think Russia will rise above those treatments and look after its own interests, and it has an interest in being a credible systemic player, and it won't be a credible systemic player if it starts throwing its weight around for no reason. So yes, I mean, it could go in a different direction if it was a different country, but with Russia, I think people are less worried. So is there a legal encouragement in establishing long-term set of rules? Absolutely, yes. For the medium to long term, absolutely. There are some questions as to the short term because of the economics. Everybody says, you know, Russia's not China, you don't export everywhere, you have very little export interest, and all your exports are being blocked in anti-dumping procedures anyway, so why do you have this economic interest? I think that's short-sighted. I think everyone knows the Russian economy has huge investments going on in value added, and eventually your resources will be turned into value added. Your industrial base is coming back. It will continue to do so. You will be an exporting country and are now and will be more so, and you'll benefit greatly from those rules. So in this set of principles, I think you come out pretty strong. So in the last points here, my prognosis is that the risk of cases against Russia, because you haven't fulfilled rules, is way overblown. I don't think people are going to bring cases against you the day after you join the World Trade Organization. I just don't think when any country joins the WTO that people use that as a way to clobber you immediately and just hit you because you're now a member. As long as Russia follows the basic rules and doesn't apply political restrictions, I think the meat cases raised some concerns where there's a foreign policy issue or something going on and all of a sudden we can't export chicken anymore. I mean, those kind of things might draw the attention of governments a bit more when it's perceived to be a political reaction rather than a legitimate trade action. And I know there are questions and justifications as to why you apply certain restrictions, but the perception is that in the near past there have been political restrictions applied, and as long as we avoid those, there shouldn't be disputes. Last is that the risk of immediate cases by Russia, I wouldn't call a risk even. I was just talking about it as a prognosis. I think other countries should feel there is a risk because they know what they've done is unfair, particularly in the area of trade remedies. However, as I said earlier, it's not. No one's in a hurry. No one's going to want to bring these cases right away. In particular, in the trade remedy side, because there are reviews annually, and your companies will go through those reviews. When they have the benefit of WTO rules, they will ask for a review and ask for those rules to be applied. And depending on the outcome of those reviews in the coming years, then we'll see how that process goes along. And I'll end with a final point. that I think the best way for the Russian government to go forward, I'm sure you're already thinking of it, but for the private sector, for lawyers and businesses to think about when disputes happen, they will happen immediately. You know, the 440th case will come when you're a member, and you will have the right to participate in that dispute as a third party. The best way to learn, the best way to be involved in disputes without anything to lose and just protecting your systemic interest is to participate as a third party. It costs nothing. It's a great learning experience. It's something that the private sector can encourage, can support, can pay for part of the legal fees to give ideas to the government. But I think that's where the kind of credibility will be established, if people see Russia being a real player in the system and contributing to the development of jurisprudence and influencing the system as it should as a great country. Thank you very much.
Thank you very much. I also would like to share your optimism, but I can sell a small secret that now we have a long line of the Russian companies which got tired because of those barriers applied to them maybe for 30 years already, and they just striving for justice, just immediate justice, taking into account the dragging procedures in the WTO. Nothing can be done overnight, but still they would try their best. Colleagues, I believe now we can start discussion of these three topics: the Russian legislation, bringing it into compliance with the WTO rules and other issues. If you have any questions, Mike, please. Speaks without microphone. I think yes. Yeah, it would be better if you speak into microphone. Can you tell what are the problems for the Russian Federation after the joining the WTO in the antitrust legislation and in the banking sector? I would ask probably Ekaterina, as the former negotiator in the service issues. She will tell you about the banking and antitrust legislation. The antitrust and competitive legislation is a more general issue. All normative acts which are governing the foreign trade, they were studied or scrutinized under magnified glass by our partners in negotiations. So we do not have any feelings that we will face any problems with the antitrust legislation which would require some changes. So everything would remain as it is now. As far as the banking sector is concerned, then the banking legislation and the changes in it, this is the result of our negotiations on the access to the market, to the Russian market by the Russian entities. And we have agreed upon that, and the most painful for our bankers and for the foreign bankers, two issues: the access to the Russian market of the direct subsidiaries without establishing the legal person in the territory of the Russian Federation. By the foreign banks, it was solved in a positive manner for Russian bankers. So we don't have any obligations which provide for direct operation of the foreign bank in the territory of the Russian Federation. Of course, we can decide otherwise, but it would be the decision of the Russian Federation independently, without any pressure from outside world. The second element, second question, painful question, the quotes, amount of quotes of the foreign presence in the Russian market. So we can apply this quote at the level of 50%. So they can be limited. The foreign participation can be limited to the 50%, but the application of these requirements is not so big because these quotes do not apply because our banking law legislation says that these quotes can be established, but as far as I know, it just worked for 1 year only, and recently it hasn't been in application, and there are no plan to change this, so it's purely theoretical issue. Yes, please. Thank you very much. Docent of the St. Petersburg University, the practice of the foreign trade regulation. It was very interesting for me to hear that still we're trying to join the WTO with such a subjective entity like customs union. So I just wonder, is there any practice in the WTO that the customs unions can be participant in this as members? So just the first example, the European Union. You know, the European Union is the member of the WTO as a union, and all member states are also the members of the WTO. As far as the other unions are concerned, it's not a relevant operating issue because all those customs unions existing in the world at large, they still fail to reach the level of integration as compared with the European Union or our customs union. It's not a relevant issue because the competence to govern the foreign trade activities is still maintained at the national level. Of course, some barriers are removed in the trade between the countries. There are single or common tariffs, but still the decision-making is just limited by the coordination between the member states in terms of governing the foreign trade. So the issue of membership is not so relevant as compared with the European Union or our customs union. How procedurally are you going to address the issue if at this stage of the joining of the WTO with our customs union, but it is open-ended union which doesn't preclude the joining of other countries to this union? We are going to limit the membership in this union. Are you going to limit this membership in the union, customs union? We're not looking so far ahead. So far, we don't have a question how procedurally are we going to solve the issue of joining the customs union to the WTO. There are no precedents so far, so we can hypothetically discuss this issue, but I hardly believe one can answer this. Of course, our customs union will join in this. Thank you. My question to Mr. Crosby. I listened to how brilliantly he speaks in Russian. I just asked my question in Russian. I just listened quite carefully. Your optimistic picture regarding the procedures of dispute resolution under the WTO rules, but somehow I looked at these arguments at the background of the multi-year disputes in the WTO between two big manufacturers of air carriers, Airbus and Boeing. So they just overloaded this mechanism with the mutual claims, and all decisions are made in a balanced manner which allow both sides to claim victory in this litigation. But in a nutshell, this litigation is still dragging. So my question is to what extent this is the reflection of the efficiency of this dispute resolution mechanism. Thank you very much for your question. I believe I will answer your question in Russian as well. Regarding the system, there are some procedures performance. This is a contentious issues. Then the development of countries which can hardly solve the legal in the legal manner, and Airbus, Boeing. So far, I don't know. I can cite maybe about other procedures. Maybe it's not a good thing for the entire system, but personally, I don't understand this thing, because I believe this dispute between Airbus and Boeing, of course, it's a big problem and clash of interest for the Europe and the United States. It's quite a complicated problem, but I wouldn't like to characterize this system through the lens of this problem. Usually, these disputes are to be solved not in such manner as we now see in this litigation. Both companies, I can hardly hear him. I just would like to clarify one point. Neither Airbus nor Boeing can use their own interests using these systems. If the state agrees to go this way, then that would be a mistake by this state. But I believe Scott would answer this question better, related to from the side of Airbus. Microphone.
It's taking what would be very antagonistic situations politically and giving you a neutral forum to decide those and allow lawyers to argue as opposed to have generals argue. And that's the way I believe in this system. Sure, there's going to be cases like that. There's very political cases involving exports of raw material by China. I mean, there's the cotton case that I worked on for Brazil, going against U.S. cotton subsidies. Nothing could be more political in the United States than cotton subsidies. But it sent a very big message, winning that case, a big message to the United States and the European Union, who were heavily subsidizing their agriculture, that developing countries were not going to accept that anymore. I think you have to realize on these big cases, there are big multiplier effects. Big multiplier effects. And they influence many other cases, and they provide much more clarity to the rules. Daniel's absolutely right that the clarity of the jurisprudence and the rules gives you guidance on how to change your legislation, and it gives you guidance on what to do and what not to do to avoid disputes. And that's critical.
I always thought that neutral was something different from ambivalent.
Not going to answer that.
Спасибо. Еще один вопрос, пожалуйста.
Thank you. One more question.
Марина Трунг-Федорова, научный.
Marina Trunk-Fedorova, Kelt University. Just a brief question regarding the customs union. Everything is clear, everything is agreed upon, and external borders regarding the access of goods. They are in compliance with the rules for the accession of Russia to the WTO. Kazakhstan is also negotiating its accession, and as far as I know, they conceded even more as compared with Russia. So if they join the WTO, what would it mean for Russia? Would we face tougher obligations, or we try to bring Kazakhstan back to those positions? And then what would be with Belarus? Join diplomacy or what? Thanks God, WTO has rules applicable to these situations regarding the establishment of the customs union or joining of the customs union to the WTO. There are rules which provide for negotiations in order to harmonize the trade regime. Kazakhstan, you were right, they negotiated lower tariffs as Russia did, and of course we use these procedures, normal procedures under the WTO, which would allow to establish the common tariffs and duties for Kazakhstan and Russia. So we bring the Kazakhstani duties to higher Russian ones, but we should be realists. Of course, that would result in lowering Russian duties, but taking into account the trade volume and the missed opportunities of Kazakhstan partners because of these changes or increasing the duties, the effect would be minimum as compared with our tariffs and duties. Belarus, formally the situation is different since Belarus has signed a number of protocols. They completed the negotiation and tariff negotiations with a number of partners, but the number of discrepancies which would require the negotiations, additional negotiations, so actually there are none of them. Thank you very much. The last question before we proceed to the second part of this meeting. Uranov Alexander, Federal Chamber of Lawyers, regarding the ratification of these documents. What would be the procedure? All documents would be ratified by the State Duma, or just partially, or this issue is not solved? And if some changes are made into this document, would we have time just to get rid of all translation mistakes and all nuances? I will answer your question. I will use in the wording of the Minister of Foreign Affairs, since it is responsible for this. Since document is signed in English, and it would be ratified, submitted for ratification in English, and Russian translation would be signed after the ratification of this. After this, Russian version would get the status of the official document, and those errors or mistakes which still exist there, we are working on them. But the status of the official text, as our colleagues explained to us from the Ministry of Foreign Affairs, they do not have a legal meaning for the purposes of all disputes to be settled within WTO, since the English text would prevail and Eurasian Economic Commission should be guided also by the text of those agreements in the languages they were signed in. So this is the position of Ministry of Foreign Affairs. Whether it's a change or not, we should look. So all documents, yes, all documents would be submitted for ratifications under which Russia assumes some obligations. That is why it's called a package of arrangements or agreements. No. We submitting the protocol on accession with all the amendments and annexes which have been agreed upon. But the Marrakesh agreement to which we join would be ratified through the protocol of accession. This is the structure which applied. Colleagues, I would suggest that we proceed to the second part, the most interesting. We potentially invite the experts in trade policies. Here we would discuss the issues of application of countervailing duties, safeguards measures, and first would be Scott to speak about safeguard measures.
It's great to be here. It's wonderful to be on the same dais with your great negotiators who did a very good job and a long job. And we look forward to welcoming all of you to Geneva and as part of the WTO family. If there are any lawyers out in this audience here, and if these lawyers work for a government, the Russian government, or you represent Russian clients, then you're going to have to become WTO lawyers, whether you like it or not. Your time has come, and the rules of trade are the WTO rules. You have to learn them. You have to at least be able to spot issues and to be able to tell your government officials about these issues, and you have to tell your clients about them. They have to be aware of them. I'm going to talk now, very briefly, about a subject that to be honest, is extremely complicated. I've been asked to summarize all of trade remedies in 12 minutes, so I'll do the best I can. What are trade remedies? That's the first question. I define them as rights under the GATT and the WTO rules that allow members to initiate investigations and impose higher tariffs against imported goods than otherwise permitted if there's material injury or serious injury caused by imports. So these are both rights that Russia has to take these actions. There's also an obligation. There's an obligation that you follow the procedures, and there are very detailed procedures on how to conduct these investigations. And if you don't follow them properly, they can be challenged in WTO dispute settlement. And just one word before I get started here. The reason that you care about these rules and the reason you have to become WTO lawyers is because these rules are binding. Now, what does that mean? Daniel just talked about WTO dispute settlement. What's unique about the WTO is that those rules are binding. If you don't follow those rules, the other WTO members can take you to dispute settlement, and if you don't change your measure, then they can retaliate against you. They can start imposing higher tariffs against your exports to their country, and they can really mess up your trade. And they can even spill over into your services or intellectual property. So WTO members pay very close attention to these decisions, and it's frankly the rare case when a member does not change their law or their measure when they lose a case, because they're worried about these sanctions. So that's quite unique in international, public international law, and the WTO has been wildly successful. These big numbers that Daniel put up on the board here are extraordinary. Those are more disputes being resolved than in the entire history of the world in the span of only 16 years, economic disputes. So I can't emphasize that enough. All right, so there's three forms of trade remedies that I'm going to talk about. First are anti-dumping measures to combat unfair dumping of goods that materially injure the domestic industry producing goods that are like the imported goods. The second are countervailing duty measures that redress material injury to the domestic industry caused by the import of unfairly subsidized goods. These are countervailing duties, and they counteract the effect of the subsidies. And finally, there are safeguard measures to redress serious injury to a domestic industry producing like products caused by surges of imported goods otherwise traded fairly, and that surge could not have been anticipated at the time the tariff concession was made. So these are three forms of measures. These are measures, all of which Russian businesses who are concerned about imports from other countries can petition the Russian government to investigate to determine whether or not there's a valid basis for taking protective action by raising tariffs against these imports. So I heard a lot of noise here about a fear about Russian businesses not being able to compete. These safeguard measures and these anti-dumping and countervailing duty trade measures exist to protect domestic industries from those types of injurious imports that can come in if the procedures are followed and if the conditions are appropriate. So we're just going to talk about the basic rules here really, really fast. And I would say also the existence of these trade remedies allow your negotiators to make the kind of tariff concessions and the tariff cuts they made in the negotiations, because they knew that they could cut their tariffs to a pretty low level, and if there ever were a surge of imports, or if there were dumped imports or unfairly subsidized imports, that they could raise the tariffs higher, above the agreed rate. And that's what these rules do. They basically allow you to go to impose higher tariffs than you otherwise would be allowed to. All right, let's first talk about anti-dumping quickly. So dumping, and these are all magic terms in the agreements. And I'm sorry to tell you lawyers that there's about probably 20,000 pages of jurisprudence out there right now that talk about all of these definitions. So you can't just read the WTO agreements. You have to be aware of the jurisprudence as well. But I think Greg's going to tell you about some tools that he's developed that will make it easier to research. So dumping is an export price that's less than normal value. So what's an export price? An export price is the price to an independent customer in an export market. So if a Russian company sells into the EU market, it's the price in the EU market. The normal value is the domestic market price. So again, if we've got a Russian company, it's the price that the Russian company sells a product in the Russian domestic market. Now, you can determine normal value by that actual prices, or if there's a reason for the investigator to think that those prices aren't legitimate, you can use other methods to determine the normal value. That's production, selling, and administrative costs plus profit, and then there's constructed value, sometimes using third country markets as a proxy. So once you determine normal value and the export price, then it's just the question of, well, the amount of dumping is the difference between the export price and the normal value. So it's, and if it's negative, then that provides you with a dumping margin, and then you're allowed to impose a higher tariffs equal to the dumping margin. Now, you can only do that, however, if the imports have caused material injury to the Russian domestic industry, or in the case of the Russian company exporting to the EU, that the EU domestic industry has been materially injured. And that's not a difficult standard many times to prove, because you only have to prove that the imports are one of several causes that may have put them into a material injured condition, where they're losing employment, where their sales have gone down. In the United States, I worked at the International Trade Commission, and about half the cases that they were able to prove material injury. Again, what's critical about the anti-dumping investigation is that it has to be done properly. When you read the anti-dumping rules in the WTO agreements and all the jurisprudence, all of these disputes are always about, did you follow the procedures properly? So it's very important for your investigating authorities to be aware of the jurisprudence and to follow those carefully. If they do, then you should be in pretty good shape. Let's just look at the number of anti-dumping measures. I mean, there are a lot of them every year. This is 2010, and this is the total number of anti-dumping measures existing in that year. You can see the United States has almost 250. India is a big, big user. So is the EU, Turkey and China, Argentina. I mean, these are all export markets for Russian goods. Before the WTO accession, those countries could take action against Russian goods, and what could Russia do? You had no forum to go and complain about that. But now you do. So now when India imposes unfair anti-dumping duties or countervailing duties against you, you can bring them to the WTO dispute, or you can threaten, as Daniel Property said, you can threaten a dispute against them. A good example of that is the European Union was having problems with anti-dumping investigations by India, and they had a whole long series of complaints. And they sat down with India, and they were able to settle all of those because I think the European Union convinced the Indians that they were going to win in the WTO. So you had a whole series of cases that were able to be settled with respect to anti-dumping. So this is a potentially very big deal, and I would argue a very, very big benefit for Russia in joining the WTO, precisely because of these large number of anti-dumping cases. And there are existing anti-dumping orders from many previous years before Russia's accession, and you may be able to challenge some of those as well. That's something you'd have to look into carefully. So that's another advantage as well of joining the WTO. All right, let's move on to countervailing duties. Okay, so that's anti-dumping. Let's talk about countervailing duties. This is similar to anti-dumping, but the focus is not on dumped imports, but rather on subsidized imports. So this is a situation where, say, an EU company producing tomatoes gets heavy agricultural subsidies to produce tomatoes, and they ship them across the border into Russia, and they sell them at prices which is causing injury to the Russian tomato market. With all this hot weather, I'm thinking of tomatoes. In that situation, the Russian authorities could bring a countervailing duty case against the EU tomatoes, claiming that because of the subsidies, they would first establish the level of the subsidies, how much subsidies did the EU provide, and then they'd be able to use that level of subsidies as a basis for showing that the imports had caused injury and that the amount of the subsidization found should be the amount of countervailing duties that should be imposed. There are technical rules that you'd follow to find whether there was a subsidy or not. Usually with the EU and agricultural subsidies, that's not difficult to prove. In our case, it can be much more difficult in other cases where the subsidies are more indirect. So this can be a very complicated situation. And we've certainly seen that in the aircraft cases that I've been working on. Again, the key focus here is there a subsidy? And is that subsidy specific? Now, the specificity is a really key issue here in countervailing duty cases, because sometimes governments give subsidies to a broad swath of industries and consumers. You could argue that if to the extent that Russia may be providing cheaper energy to its industries, in the form of cheaper electricity or cheaper gas or cheaper oil, that those may well be subsidies, but they're not specific subsidies because they're provided to all of the industries. And I know your negotiators in the WTO argued very, very strongly that those type of energy subsidies, if they were subsidies, were certainly not specific, and therefore wouldn't be the basis for a countervailing duty cases against goods of Russian goods that may have benefited from those lower energy prices. Finally, the third remedy is called a safeguard measure. Now, the first two remedies, anti-dumping and countervailing duties, involve the export and importation of unfair imports. Those were imports that were dumped or they were subsidized. And in the safeguard situation, you don't worry about whether the imports have been unfairly traded, unfairly dumped, or subsidized. You just look at the amount of the imports that are coming in. So in our tomato example, all right, let's say that those tomatoes coming from the EU into Russia, they weren't subsidized at all. They weren't dumped. There was just a whole lot of them. You know, the EU put trainloads of tomatoes and you dumped them in the St. Petersburg Square here, and everybody was buying them up, and the Russian tomato industry suffered a big loss and suffered material injury. Those would be the kind of facts that you could establish a safeguard case. Now, to do that, there's three elements that you'd have to prove. You'd first have to prove that there's a recent surge in import volume. Okay, so we've done that. I mean, we have this huge surge of tomatoes that have come into St. Petersburg. We have to show that it was unforeseen at the time of the trade concession, and in this case, it was the trade concession was you're lowering your tomato tariff during the accession negotiations, and that it was unforeseen that during those negotiations that anybody could have anticipated the EU out of nowhere would start shipping very large quantities of tomatoes into the Russian market. And again, you have to prove on this material injury point that the surge of imports has caused or threatened to cause the domestic industry, in this case the Russian tomato industry, producing products, that industry is suffering serious injury. Now, you'll notice that the test here for injury in the safeguards is not material injury, but it's serious injury. So you have to show more of an injury in a safeguard case. And finally, the remedy that you get in a safeguard measure, it's more restrictive in terms of the amount of time, because you're only allowed to apply a safeguard for a short period of time, no more than 3 years. If you apply it more than 3 years, you have to start paying compensation. But during those 3 years, you can impose very high tariffs in order to eliminate the serious prejudice to the domestic industry. So in that sense, it's much more flexible and stronger than the anti-dumping measure, which could only be the amount of the anti-dumping margin. And same with countervailing duties, you could only apply the amount of subsidization. I've got some examples of application of these on my slides. I think the organizers are going to make them available to you so you can take a look at that. Daniel mentioned trade remedies and dispute settlement, and again, another reason why you need to pay attention to these trade remedies is because this makes up about 50% of the active disputes that go to the WTO. The statistics show that about half of the requests of the total 436 disputes filed have been on trade remedy matters. Anti-dumping duties have made up about 20%, CVD or subsidies another 20%, and safeguards about 10%. So these are cases that are brought an awful lot by WTO members. There are strategic considerations to follow in these cases. For example, the strategic considerations to challenge trade remedy actions against Russian exports by other WTO members. We've heard a lot of talk about how Russia has been hurt over the years. I think it was 30 years of trade remedy action, right, against Russian exports. So that's a very common problem that Russian exporters face. Russia, on behalf of those exporters, can bring challenges in the WTO or try to negotiate a solution to those. Those are sometimes not difficult cases to make because there's so many procedures that it's difficult for investigating authorities to get everything exactly right all the time. But you wouldn't want to bring a case in a WTO unless you really thought that the error was so severe that there was nothing the investigating authority could do to change it when they would lose the case. So you need to be smart and strategic about the kind of cases that you bring on that. And sometimes you can need to consider that under EU and US law, appealing to the local courts can be a faster and sometimes more effective remedy, although many times you're better off going before a WTO panel than a US or EU court. Same thing in terms of the strategy for Russian domestic industries that are worried about imports. If they can get the government to successfully bring an investigation and to find that there's dumping or countervailing duties or to impose a safeguard measure, even if those measures are challenged, time is going to be on the side of the domestic industry. And as a practical matter, you'll get a de facto safeguard out of this measure because it'll take about 2 or 3 years to work its way through the WTO dispute settlement system. So that during that period of time, it would allow Russian authorities to fix the problem, or the domestic industry could adjust during that period of time. So sometimes it's good to negotiate. Other times it may be useful if it's an important enough domestic industry for the Russian government to say, well, let's just go to a dispute, and they'll go through the 3 years or so that it would take to resolve that. All right, that's probably more than 12 minutes. All I can tell you is those are the basics. It's much more complicated than that. It's not something that you can do easily, but I think it's important for you to be able to spot these issues so you can call up experts in the government and develop your own expertise over time to be able to handle these kind of disputes. Okay, thanks.
Thank you so much. And we have last topic, which deals with technical regulation. Greg, Russian manufacturers of helicopters for 9 years tried to sell their choppers to one of the 2 countries of Northern America. And within all those years, it is requested to change the design of the fuel tank. And once the manufacturer changes the design of the fuel tank, he's told that you have to redesign it again in order to comply with the safety measures. So what goes on in the area of WTO technical regulation, how we can protect our interest in that area?
It is a true honor to be here on this prestigious panel. I do understand that it is the end of the day and things are warm in here, so I will shorten my presentation a bit. In the process of my presentation, I will address the helicopters issue, although I'll build it into the presentation. Now, my presentation is on technical barriers to trade, specifically technical barriers that are governed by the Agreement on Technical Barriers to Trade, or the TBT agreement. And I'd like you to keep 4 things in mind when I make this presentation because they illustrate some of the points that have already been made by the presenters before me. Number 1 is the balancing of regulatory and trade policy. When you're looking at TBT measures, there's this huge friction between the regulators who want lots of space, want to be able to regulate how they want to be able to create safety standards however they want to do it. And then there's the trade side, which is you don't want unnecessary obstacles to trade. So keep that balancing in mind. The second thing is the clarification of rules through dispute settlement. We heard a lot about that. And in this particular agreement, it's very important because the key provisions of this agreement are very difficult to understand and can only be understood in light of the new jurisprudence that's just coming out right now. The third thing is the resolution of disputes. As we get a clearer framework on what the TBT agreement means, in particular these obligations I will be discussing, as those become clearer, future disputes are going to dissipate. So problems that countries may have with Russian regulations today when they look at those regulations again, with a new understanding of what the law really means, they may not have problems. The fourth point I'd like to demonstrate in this presentation is the role of third parties, because it shows that your role as a third party goes beyond simply understanding how the system works and getting experience, but it's laying down the foundation for future cases and for defending your future interests. So very quickly on the TBT agreement. The TBT agreement governs three types of things. One are product standards. Most of the things you see in the world are voluntary product standards. If you look at your computer, there's all sorts of standards that are listed on that. Very little government intervention. There are tens of thousands of product standards out there. There's very few technical regulations. You look at the average WTO member, they may have 1,000 or 2,000 technical regulations operating within their jurisdiction, and there's tens of thousands of product standards. Now, I'm going to be focusing on technical regulations in this presentation because that's where the government regulates. So the government moves in and decides that there must be a certain standard for safety standards on helicopters. The government intervenes, sets that standard. That becomes a technical regulation as soon as the government intervenes. I won't get into the law of what turns a standard into a technical regulation, but that's one of the new areas that's recently been developed. I will also not be discussing conformity assessment procedures, which are another big area of TBT law. In the slides, there are some examples of what technical regulations are. We'll just skip over those. There's also examples of the types of concerns that have been raised before the TBT committee and the WTO. And what you'll see is technical regulations form a very big part of those concerns, almost 90%. And if we look at what the main concerns are, one of the big ones is an unnecessary obstacle to trade, and there again we come back to the helicopters example. Now, what are the key obligations in the agreement? And this again is very important because this sets the parameters for what regulators can do in Russia, and it also sets the parameters of what Russia can expect when they're trying to get into other markets. And it's a real balancing. So the stronger you argue a case from a trade perspective, the more upset your regulators get. And so Natalia and I just finished 3 appeals on the TBT agreement. One was clove cigarettes, the other was tuna dolphin, and then the Cool case. And one of the big challenges we faced is that our client, the government of Mexico, had regulators on one side saying, don't argue for a strong trade case, and then you had the trade people on the other side saying, make sure the rules are very, very strict on trade. And what's happened with the appellate body, understanding this balancing, it has interpreted these provisions now in a way that balances those two approaches or those two perspectives on these issues. So this first slide is the non-discrimination obligation. And it's very, very interesting because under the TBT agreement, the rule simply is if you discriminate in any way, it's prohibited. And for example, a particular regulation that would ban all Russian helicopters but allow all US helicopters on its face would violate Article 2.1 of the TBT agreement. It would be prohibited. Now there's a problem with that type of analysis because it's far too strict. The regulators would go crazy because there may be a legitimate reason for creating this type of discrimination. So what the appellate body has created is this new concept called legitimate regulatory distinction. And this came out of the first appeal that was issued this year in clove cigarettes. And what it states is simply this. First, you look at whether there's discrimination in the traditional sense. But then what you have to look at is you have to examine the discrimination and see, is that discrimination because there's a legitimate regulatory distinction? And when we look at the example of helicopters, what you would be looking at is the difference purely arbitrary? Is there really a safety problem with the design of the Russian fuel tanks? Or is it something more? Is there something arbitrary about it? And I'll be showing a couple examples of cases that get into that issue of what arbitrariness would be. But on the helicopter case, it would become very factual, and it would be looking at, is there a legitimate regulatory distinction that's underlying that type of discrimination? The second very important obligation in the TBT agreement is an obligation not to create unnecessary obstacles to trade. Now, why is this important? It's important because if your measure does not discriminate, so it treats everybody equally, yet it slows trade down, can you challenge that particular measure? And a really good example in the Canadian context is the treatment of alcoholic beverages. In Canada, in most provinces, you cannot buy alcoholic beverages, wine or beer, or any other alcoholic beverage from a private party. There's one seller, it's the government, and the government buys everything. You go to government liquor stores and you buy your alcohol. Creating that type of system reduces competitive opportunities because sellers or exporters of wine and alcoholic products to Canada don't have opportunities to sell on their own. It restricts their volumes, it restricts their ability to actually get listed on the shelf. Very clearly, it's a restriction. And the big question becomes, is it an unnecessary obstacle to trade? Very clearly, it restricts trade, but is it unnecessary? And so the appellate body has now clarified the meaning of this particular provision, and it's focused heavily on the necessity test and is the measure necessary to fulfill a legitimate objective. And on the discussion of what a legitimate objective is, the two recent cases that came out, interpreted it very broadly. It took a regulatory or a regulator's perspective and said, legitimate objective can almost be anything. Now, from a trade perspective, the trade lawyers weren't too happy with that because they would like it to be narrowed. Only in certain cases is an objective legitimate. Obviously, human health is legitimate, but consumer information on country of origin, which is one of the cases, arguably would not be. And the appellate body seems to be going very broadly on this point. Almost anything that has a reasonable regulatory basis will be found to be legitimate. And what this means is that the necessity test, which is a very well-developed and in-depth area of law in WTO, is now going to become the benchmark to determine whether a measure is an unnecessary obstacle or not. So that's the unnecessary obstacles to trade provision, Article 2.2. Now, I mentioned legitimate objectives, and it comes up in two contexts. For Article 2.2, which is unnecessary obstacles to trade, it's one of the legal thresholds that the measure must fulfill a legitimate objective. Under discrimination, you must look at whether there is a legitimate regulatory distinction, and part of that is you look at the legitimacy of the objective. This slide just shows some examples of what those objectives would be. The protection of human health and safety being number one. There's consumer information, protection of the environment, etc., as you go down the list. So I'm going to very quickly go through just a few recent WTO disputes to explain how they've changed the law. Clove cigarettes was the first case, and it set the benchmark for the new test for discrimination. And that is that merely because it's discriminating doesn't mean it's bad. You must look at whether there's a legitimate regulatory distinction underlying it. This case also illustrates the importance of third-party participation. This entire decision was based on oral arguments made by Mexico as a third party. And the whole purpose of Mexico was to set the ground or the foundation for future cases, which were the tuna case and the Cool case, which came after this. So not only is this case important in setting out the law, it's a very good example of why Russia needs to be monitoring these cases and in certain instances participating for policy grounds so it can set the foundation for the law that will affect it in the future. Tuna Dolphin 2 is a very interesting case. It's all about dolphin safe, and anything related to the environment is affected by this case. And a very big issue for Canada right now are the European fuel standards, where you have heavy oil, or what the Europeans refer to as dirty oil, And that could potentially be discriminated against on the basis of environmental factors. So Tuna Dolphin 2 was a dispute about whether tuna that is caught in the ocean is dolphin safe or not. Under certain methods of catching tuna, you can actually injure dolphins. And what happened was there was an international agreement that regulated this type of fishing practice. Under that agreement, Mexico was entitled to have dolphin-safe tuna. The U.S. wouldn't allow them to use that label in the U.S. market, which meant that the products could not be sold. The United States basically intervened and on its own defined what dolphin-safe would mean. And so Mexico challenged this, and under the TBT agreement, initially before the panel, they won on the basis it was an unnecessary obstacle to trade. But yesterday, the appellate body came out with a new decision which overturned the panel and found that this particular measure on dolphin-safe labeling was discriminatory and was not based on a legitimate regulatory distinction. The third case is still under appeal. It's the U.S. country of origin labeling case. This is a great illustration of how you can design a measure that on its face looks great. It's non-discriminatory, it looks completely legitimate, yet it blocks imports. And what this was all about was made in USA beef and pork. The way the measure was implemented, the most cost-effective way for the industry to implement the measure was to not carry Mexican cattle and not carry Canadian cattle and Canadian hogs. And so that was the de facto discrimination that was complained about. And before the panel, Mexico and Canada won that case, where the panel found it was both discriminatory and an unnecessary obstacle to trade. A number of the legal issues are now before the appellate body, and we're waiting for the decision in that case. Australia plain packaging is a case that's just being started up. Very, very interesting. This is about plain packaging on cigarettes, getting rid of the trademarks. There will be some interesting discrimination and obstacle to trade issues there. And the other one, which I didn't have a slide for, which we mentioned earlier in the presentation, is the seals case. And so Canada's challenging the European Union's ban on seal products under the TBT agreement as well as the GATT. And that will raise some very interesting issues. And when Russia becomes part of the WTO, it's quite possible that Canada will extend or bring another challenge of measures that were put in place against seal products in Russia. The interesting part, though, is in the seal products case, is it a legitimate regulatory distinction? Is it a legitimate objective? And that's something that will be very interesting in the context of animal rights and animal health. So, in conclusion, the TBT agreement reflects, at least as it's now been interpreted, reflects a very specific balance between the regulators who want to regulate and the trade policy people and the trade interests of the WTO members. So that completes my presentation, and I'm open to any questions. Thank you.
Спасибо большое. Пожалуйста, коллеги.
Thank you very much. Colleagues, please, questions regarding technical regulation procedures. Safeguards measures. Can I ask a bit different questions, not on these topics? Let's first deal with these two topics regarding the protection of domestic market and technical regulation, and then, yes, please. Hello, I have a question on technical regulation to Ekaterina, because it is closely related to the customs union. You mentioned about the multi-party trade system. Now we heard the presentation about TBT, and you made the assessment. To what extent will we be obliged to change the technical regulation system? Because as far as I understand, after we joined the WTO, 183 WTO member states would like to participate in this process, and to what extent we're going to change the technical regulations. I don't think that we have to change something because the procedures for adoption of technical regulation parameters existed in the customs union. In fact, it was copied from our legislation on technical regulation, and all basic parameters, including dates for consultations with the parties concerned on the draft of technical regulations, were actually reflected there. So the existing procedures in the customs union is in compliance with the rules of the WTO, as well as all other legal requirements. They were scrutinized in a greater detail in the negotiation process, and all shortcomings were removed, and we should focus on rather regulations or rules of the operation of our new supranational authority, Eurasian Economic Commission. So we should look into the regulations and procedures of this body in order to ensure their compliance with the WTO, so that to ensure the technical regulations. So we have to make some changes into this, because each time we discuss the changes into the regulations of the customs union, so the national players are involved in this without participation of the foreign players or participants. This process is open or accessible for comments, especially regarding the draft of new technical regulations, and comments could be provided by the representatives of the foreign government. And this is now the case. We receive a lot of comments from them. Colleagues? I have a question to Greg. We have a long-standing dispute with colleagues from Brussels regarding that we do not allow the import of meat with a high degree of tetracycline. Tetracycline is used by population as a medicine to treat many diseases, but it's not used in the European Union. So you can hardly find it in the pharmacies in the European countries. I mean, for the human treatment in the European countries. It's not sold in the European Union, but it is treated on the animals. So our services prohibited the import of this meat with the high content of this tetracycline, because the daily consumption would develop the resistance of the organism to some diseases. So, from your point, can you, maybe it's premature to say who is to blame in this dispute, but is this dispute is in the framework of the TBT structure, or it is related to the dispute between the sanitary services of our respective entities? Because there are some differences, and they have different history and different future.
Sanitary phytosanitary measure simply because it's dealing with a food product. Now, if you were dealing with labeling on tetracycline and that was affecting, consumer buying patterns, then it would probably be more TBT agreement. But the great thing about the SPS agreement, and I might add that tetracycline is used in Canada throughout the market, and we don't see any problems, at least yet. So, but it comes down to use of antibiotics in animals. And under the SPS agreement, whenever you have a trade restriction that's based on that type of measure, it comes down to the risk assessment and all the scientific requirements, which are very, very detailed. The TBT agreement doesn't have this wonderful risk assessment framework. There's nothing as objective as that in the TBT agreement. It's one of the deficiencies. So when you're trying to determine whether something's legitimate under the TBT agreement, it's in the air, legitimate, objective, all these subjective terms. But under the SPS agreement for something like this, it's extremely scientific. And there's a huge amount of jurisprudence on this. Scott was nice enough to mention earlier that there is a tool out there that helps you find all this law. It's called Trade Law Guide, but it sets out all of these steps for you that what is a risk assessment. And so it's not enough to simply say, we've got a problem with an antibiotic. They have to go through the steps and do it objectively. Now, if there's truly a problem with that from a scientific basis that can be proven, that type of measure will withstand scrutiny. But you just can't say, we don't use it, we haven't tested it, you can't have it. That is arbitrary. They have to show that there's a proper risk assessment that's been conducted.
When the science changes over time or the conditions change over time, you have to update your risk assessment. So, Russia needs to be careful about that. So if you want to continue to justify this, you better keep your scientists, and you have lots of them here, keep your scientists busy producing risk assessments and looking for analysis. And that could be minority science. It doesn't have to be majority science. That would be fine to justify.
Yeah, and just to add to that point that Scott made,
Greg, give them your website.
It reinforces a point that Scott mentioned about getting the industry involved. And Daniel mentioned that as well, that on these types of cases, as a government, it's a nightmare of costs, anything to do with bringing in scientists and doing analyses. And if you have the industry involved and behind it, they can help you with the science. You have your own internal scientists that can work on this. But building your case up front is absolutely key. You want to understand that you have the science behind you before you would even launch a case on this type of issue. And you'd want it all done up front. So just a small point there.
Microphone, please. Microphone. I will start over again. I just would like to add to this discussion the piece of information that US and EU signed the agreement on organic additives, so they have technical regulations to govern the organic goods. In February, they signed the agreement that they would recognize the standards of each other on organic goods, but there is an interesting exclusion which deals with the antibiotics. United States does not recognize the Europeans use antibiotics to treat animals, and Europeans do not recognize that the US uses antibiotics or some chemical substances to treat the fruit plants. This is just the information or a sort of food for thought. So what our dear partners are doing at that time. Thank you very much. A question? Kranitskaya Elena, a lawyer, trade practice, Crown Morin, Brussels, legal company. You mentioned about dispute between Canada regarding prohibition of seal skins, import of seal skins, and taking into account the advantage of participation of third countries. Can Russia participate as a third party in this dispute because it deals with the TBT? You know, we don't consider the participation in any disputes because so far, first thing that we need to do is just to complete the process of accession and become a full-fledged member of the WTO. And secondly, we are not fully convinced that in this there is a sense of being a third party, because after this dispute started, many countries introduced similar bans. Croatia, United States, Switzerland is considering to impose this ban. So I believe this dispute would rather end not in the favor of those countries favoring the free trade of seal skins. Let's see and wait, but so far we don't have such plans. Yes, please.
I want to say that luckily, there's not a majority vote in dispute settlement, and it may well be that Norway and Canada have the better of the argument when they get before a panel. The fact that there may be 10 third parties against them, or many other parties against them, doesn't say anything about the merits of the case.
Это правда.
Just maybe another addition, just to reflect this difficult situation, not only from the point of view of non-tariff and tariff regulations, but phytosanitary measures adopted by Russia. To what extent, in the framework of the WTO, we would be pressurized by the WTO member states, especially in the light of restrictions on a dozen of companies or importers of frozen fish products like salmon and others. So these measures are often applied. To what extent can we predict the tougher measures against Russia when we join the WTO? This question goes to whom? I'll try. Oh, it's a sort of rhetoric. It's not a rhetoric question. I try to answer this. It's purely commercial issue. You know, we have been working closely with our sanitary and phytosanitary services. We can split this question in two parts. First part deals with the measures which many our partners consider as discriminatory. They make complaints against us. But if you look into the reasons and ask a question to yourself, do I really want to eat this kind of fish? Then after reading this, the content of this fish, then I believe you immediately decide against this, because we fight for good and healthy products in our shops. Second question is that sometimes the scientific justification in the required format, as it is requested by the WTO rules, are provided in a timely manner because of our system. So this system should change. We should finance these changes. That would require some time. But I don't think that it would make principal changes, because these measures are made not because of somebody's will. But WTO does not prohibit to introduce measures aimed at protecting the health of their citizens. Yes, you are right, and maybe the third aspect is just to make the decision-making procedures regarding these measures more transparent, because the way these measures are made now sometimes have quite blank spaces. Yes, my kid just ended up in the hospital after eating this kind of products. That is why I understand the situation quite well. But as consumers, we can be on both sides. Today on this side, then next day on the other side. But sometimes for foreign companies, it's very difficult to figure out the system, how the way Russian system is working. So, of course, some changes should be made to that. I probably tend to agree with you, but I can put the box of champagne to somebody who can figure out the way the European system is operating, or European Union system working.
Respond to the point of whether Russia will come under pressure. And I think, yes, I mean, the government, and I think everyone realizes that the government will obviously come under pressure because there's a new set of rules. My earlier statement that I don't think there will be a barrage of disputes right away, I stand by that. I know, Maxime, it's no secret that there's a long list of companies who complain, as they always do. The question is whether governments are going to be willing to take those private sector complaints to you right away after the accession. It would be completely normal for one or two disputes to come in the course of time and then to have disputes as a complainant and respondent. But I really think that the government nature of the dispute settlement process puts a brake on the private sector interests that everyone is very loud and complaining about. And it's very easy for the United States government and the EU to complain very loudly when they can do nothing about it because you're not a member. As soon as you're a member, I think they will back off a little bit, because then their companies will say, if we have such a big dispute, and if you want to shout so loudly, then why don't you do something about it? So the establishment of the right, in my view, will make the governments back down a little bit in how loud they cry against these issues, and they'll have to be more reasonable when they're dealing with you. That's not to say there won't be disputes. Of course there will be, and there'll probably be a few test cases to see how you react to disputes and whether you can back things up. And if you can back things up with scientific evidence and tests, then I think governments will back off a bit. If you lose your first cases, then I think the questions will come as to maybe we should bring more.
Just one small point to add. Most SPS issues are solved through bilateral discussions, not even consultations. They're just pure bilateral discussions. And the reason they are is that SPS is a real two-way street. And that's the fact is that one industry may have problems with your fish standards or your fish SPS, but that country's got a whole bunch of other measures in place, and they don't want to go to WTO dispute settlement on an SPS measure and have a standard set that they won't be able to meet. And so what you find is that there's very few SPS cases. It's only the really big ones that make it up. But in Canada-US trade relations, we have, at any one time, probably about 20 SPS issues under discussion, getting resolved over the course of time, and we've never had a major SPS dispute go to WTO litigation. So most of them do get resolved behind the scenes.
That's exactly right. And Brazil and the U.S., for example, have a bilateral commission where they just meet and every year, and they go over all the existing SPS disputes. So to the extent Russia may want to do that with some of its other major trading partners, that's a very good system for avoiding disputes. So just, you might want to talk to your Brazilian and U.S. colleagues as the model they're using.
Thank you very much to all of you for your presentation. I would like to thank our negotiation team for the results they achieved. and for the ratification of this agreement, which is to be expected quite soon. And in this regard, in the framework of the legal forum and on the conference on the WTO rules held 2 days ago in Moscow, are you working already on creation of a system to ensure interaction between business and the governmental structure in Russia regarding the issues how to represent Russia in the system of the dispute resolution, how business can make claims, how to ensure the coordination with the customs union. And Ekaterina was fairly saying that 90% of rights are delegated to these unions. How would we deal with the lawyers? Would we follow the example of China, where they use the system of combined participation of China legal firm and the foreign one? So I know there are a lot of problems, but still, if you have any vision regarding these aspects, we would be thankful to you. Thank you very much. Indeed, we have been working on these issues for quite a while, and in the framework of my Ministry of Economic Development, we have a structure which is dealing and responsible for the dispute resolution, but in the context of Russia, this scale is bigger as compared with the WTO scale. Now we expect a new structure to be approved, a new structure of government to be approved, and depending on this structure, there will be a body, official body, probably it would be Ministry for Economic Development, which would continue to ensure the economic development of economic policy. And within this ministry, we will consider those approaches which you mentioned. There are two interesting topics involved here. Together with the business, we have to solve an issue, how to build up a system of interaction between each other. There are two models, which we have been using so far, and business sometimes turn to us and they asking, please help us solve this issue. If they are not turning to us or asking us, then we are not dealing with this problem. The second model, which exists in many WTO member states, business sends a signal saying that they do not feel comfortable in such or another market, and we as a government start participating in this process in order to find a solution to this problem together with business. The second topic which you raised, the attraction of lawyers, and not only for the dispute resolution system. It could be a specific case, but I think it would be very useful for us to see the legal companies or firms as defenders of the trade interests, and especially in the light of the WTO rules, that would be a new topic which would be an uncharted territory for our legal companies. How will we build this work so far? I don't know, because in the Russian market we don't have a company which would be professionally dealing with these WTO questions. Some legal companies start slowly posting information in internet about their willingness or readiness to deal with this. The more companies we have, the better, but because so far we are not using fully all WTO instruments. That is why we would like to encourage the participation of these companies, and we are thinking about developing a specific program to help these companies in that. Whether we are going to change to use the Chinese experience, I think yes, but eventually everything would be dependent upon the specific case. As we see from the practice of other companies or countries, some companies are working in combination with the local companies, because it is easier for them to solve the local nuances and questions. It's not my official position or response, but of course my question that we should develop our own expertise and use the experience of foreign legal companies, not to the detriment to the interest of our colleagues and partners. You know, some legal companies tend to unite in order to work successfully, because the market is quite big. Can I ask a question regarding the lawyers, since we're talking about them? Russian assumed an obligation on the market of legal services. We write to the ministry, but so far without reply. The obligations of Russia on legal services, there is a footnote dedicated to lawyers. It says that only lawyers can be representative in some court. We would like to ask why, because it deals with the monopolies of the lawyers in arbitration processes. Or is it just a fixation of specific rules for the Russian lawyers, which would be granted to them after Russia joins the WTO? Can you explain this? Katerina Evgenia, can you refresh your memory? Just coming back to my youth, I must say that this footnote appeared at the request of the Ministry of Justice, which we consulted on legal services, and it was based on either like usually on the normative acts which were enforced at that moment, or legislation, existing legislation, or legal, or some ideas presented by our legal communities. So this footnote was based on the existing, at that time, legal framework. So then I ask a question to you. The list of these services, legal services, in relation to goods, should contain the description of two exemptions: limitation of national regime and exemptions of the access to the market, without any explanations, specifications, especially in the context of our specific obligations. If it is written down, then it should be interpreted as a limitation or restriction. And without answering your question directly regarding the appearance of this footnote and an interpretation of it, but I must say that we have a lot of restrictions, a list of restrictions which are not applicable. But once they are recorded, then according to the WTO rules, they reflect our rules and our right to use these restrictions, especially in the way they are reflected in the Article 16 and 17. So they are quite confusing. And
what's the problem with the footnote? Actually, yes, there is no answer. Actually, we wrote a letter and we have never responded. We'll respond to you. I will control it myself. Dear colleagues, we are out of time, and I would like to thank everyone present here and the presenters for their contributions. The main conclusion we can make is that probably someone would lose from the accession to the WTO, but not the lawyers. Thank you.